Major breaking news. As you know, the United States Supreme Court heard oral argument this week in the United States versus Trump case dealing with whether or not the special prosecutor targeting Donald Trump, that's Jack Smith, whether or not his case against Donald Trump in the District of Columbia arising from the 2020 election and January 6th and so on, whether or not Donald Trump can be criminally charged in an Article 3 federal court or not. Donald Trump has asserted various defenses, but the one right now before the U.S. Supreme Court is whether or not he has what is known as presidential immunity that says to the extent he acted while he was the president of the United States, he cannot be criminally charged by the Department of Justice because he has immunity. Major oral argument here. You need to follow this and understand this just to understand how the Constitution works, because if you understand how the Supreme Court thinks about these kinds of issues, it will help you understand your Second Amendment rights. Very important stuff. Wait till you see what these justices had to say in 1 second. Hey folks, I'm Mark Smith, host of the Four Boxes Diner, proud American gun owner, constitutional attorney, member of the United States Supreme Court Bar, and author of many Second Amendment books, including Disarmed: What the Ukraine War Teaches Americans About the Right to Keep and Bear Arms. All right, folks, so here's the story. As you know, Donald Trump has been criminally indicted by the special prosecutor, Jack Smith, who was appointed by Merrick Garland, who undeniably is very bitter that he did not make it to the U.S. Supreme Court. So he appointed Jack Smith to basically go after Donald Trump, and Jack Smith is doing this with criminal indictments against President Trump down in Florida in front of Judge Cannon and in the District of Columbia involving allegations of voter fraud, things like this in the 2020 election, and so on and so on. I won't bore you with the details in this particular video. The bottom line, though, is that Donald Trump says that he cannot be charged. He cannot be charged with a crime for events or activities or things that he did while he was the president of the United States, because he has what's known as presidential immunity. Because as a general matter, President Trump argues, and that's basically correct, that we do not want people who are president to be criminally charged for everything they do or sued for their acts in office and so on, because, it would be just bog down the entire system. It would affect kind of how they make decisions and so on. And you already have a remedy. So if a president really does misbehave in some egregious way, you can impeach him by having the House impeach him and the Senate try and convict him and remove him from office. So there is already a remedy if someone is the president and misbehaves and commits crimes. So the argument, among other things, the argument is, hey, if he misbehaves as president, forget about indicting him after he leaves the office, just impeach him and remove him, which is what the Founding Fathers were mostly concerned about, protecting our freedom against the government and government actors. Now, keep in mind, before I play you these clips, these additional clips, we've done a few clips already, these are new clips. Notice how the U.S. Supreme Court deals with hypotheticals. And this is why I wanted to play it here, even though usually we talk about the Second Amendment. And that is because it's very important for you to understand two things. When the U.S. Supreme Court takes a case, keep in mind they only take somewhere about 60 to 75 cases a year now. So when they take a case, it's not just important for the people involved, of course it is, but it's also precedential for the entire country. So what the Supreme Court writes in their opinions in the 60 to 80 cases a year that they decide on the merits doesn't just impact the lives and the fortunes of the people that are actually parties to those particular cases, whether it be criminal or civil. It also matters the whole country, because what the Supreme Court does in particular cases will be relied upon by the lower, quote-unquote, inferior courts under Article 3. That's what lower courts are called, inferior courts under Article 3 of the U.S. Constitution. They will follow that. So it's very important to understand how the Supreme Court thinks about these cases. So you're going to see right here in a second, when the Supreme Court is asking questions, they're really trying to understand what lines they should be drawn about presidential immunity, what is presidential immunity, what is not presidential immunity, what examples would fall on one side of the line and the other side of the line. And it's very important to understand the role of hypothetical questions to these lawyers, because it helps the Supreme Court guide us. So in the Second Amendment context, you're going to get all sorts of questions about, nuclear weapons and battleships and all sorts of nonsense. But the idea is this is what the hypotheticals are for, to try to draw legal lines, whether it be in the Second Amendment context or in this case, presidential immunity. But it's important for you to understand that. So let's start off right here and right now with Justice Sam Alito talking about, you guessed it, SEAL Team 6. A SEAL Team 6 from the Navy, a hypothetical. So check out what Justice Alito has to say about SEAL Team 6 and a hypothetical to the lawyers in the Trump case.
I do think it was
I'm not quite sure why he used the word plausible, because that seems to
negate might as well give absolute if you're saying plausible, because anybody could argue plausibility. We don't even require plausible. We require reasonable in qualified immunity. So,
well, I mean, one might argue that it isn't plausibly legal to order SEAL Team 6, and I don't want to slander SEAL Team 6 because they're honorable. They're honorable officers, and they are bound by the Uniform Code of Military Justice not to obey unlawful orders. But no, I think one could say that it's not plausible that is legal, that action would be legal. And I'm sure I've thought of lots of hypotheticals. I'm sure you've thought of lots of hypotheticals where a president could say, I'm using an official power, and yet the president uses it in an absolutely outrageous manner.
That, if we're an objective determination, may well be an interesting approach to.
Now, Justice Alito also had another powerful question here to the government, dealing with government weakening the claim on immunity, how to think about these things. Check out what Justice Alito had to ask here.
The Department of Justice.
All right, so this is more, I think, than just a quarrel about terminology, whether what the former president gets is some form of immunity or some form of special protection, because it involves this difference, which I'm sure you're very well aware of. If it's just a form of special protection, in other words, statutes will be interpreted differently as applied to a former president, then that is something that has to be litigated at trial. The former president can make a motion to dismiss and may cite OLC opinions, and the district court may say, well, that's fine. I'm not bound by OLC, and I interpret it differently, so let's go to trial. And then there has to be a trial, and that may involve great expense, and it may take up a lot of time. And during the trial, the former president may be unable to engage in other activities that the former president would want to engage in. And then the outcome is dependent on the jury, the instructions to the jury, and how the jury returns a verdict, and then it has to be taken up on appeal. So the protection is greatly diluted if you take the form, if it takes the form that you have proposed. Now, why is that better?
It's better because it's more balanced. The blanket immunity that petitioner is arguing for just means that criminal prosecution is off the table unless he says that impeachment and conviction have occurred. Those are political remedies that are extremely difficult to achieve in a case where the misconduct occurs close to the end of a president's term. Congress is unlikely to crank up the machinery to do it, and if the impeachment trial has to occur after the president has left office, there's an open question about whether that can happen at all.
And what's most amusing in some ways is that Justice Alito points out the obvious, which is a president gets to pick, with the confirmation of the Senate, of course, his own attorney general. And here you have Justice Alito point out that, hey, wait a minute, if all the president cares about is getting the blessing of his own attorney general and thus get essentially absolute immunity in all instances, why doesn't he just pick his best buddy as the attorney general who will always sign off on anything the president says? And if that's the case, he will never be charged because he'll always have his absolute immunity because he will have sought and talked to the attorney general of the United States. Check this out, what Justice Alito had to say.
All right, well, we could go through other historical examples. I won't do that. Let me just touch briefly on a couple of other things. One is the relevance of advice of counsel, and I wasn't clear what your answer is. So if the president gets advice from the attorney general that something is lawful, is that an absolute defense?
Yes, I think that it is under the principle of entrapment by estoppel. This is a due process doctrine that we referred to in our reply brief in Garland versus Cargill this term at page 19, where we cited authority of this court that if a authorized government representative tells you that what you are about to do is lawful, it would be a root violation of due process to prosecute you for that.
Won't that give presidents an incentive to be sure to pick an attorney general who will reliably tell the president that it is lawful to do whatever the president wants to do if there's any possibly conceivable argument in favor of it?
So I think the constitutional structure protects against that risk. The president nominates the attorney general, and the Senate provides advice and consent. And these are the sort of structural checks that have operated for 200 years to prevent the kind of abuses that my friend fears going forward as a result of this once-in-history prosecution.
Now, for some reason, federal judges seem to like to talk about nuclear weapons and nuclear issues. So here you have a discussion during the presidential immunity discussion before the U.S. Supreme Court about whether or not a president who sells nuclear secrets or stages a coup, what does all that mean hypothetically, and what does that tell us, if anything, about where the line should be drawn between what might be an official act of the president versus a private act of the president? Sometimes, keep in mind, you might also have discussions in the context of what is the role of an office holder like the president versus an office seeker, who's someone who is a candidate trying to seek a particular office. Nevertheless, let's check out this questions about nuclear secrets and staging a coup.
If a president sells nuclear secrets to a foreign adversary, is that immune?
That sounds like, similar to the bribery example, likely not immune. Now, if it's structured as an official act, he would have to be impeached and convicted first before.
What does that mean if it's structured as an official act?
Well, I don't know in the hypothetical whether or not that would be an official act. You'd probably have to have more details to apply the blazing game analysis or even the Fitzgerald analysis that we've been talking about.
How about if a president orders the military to stage a coup?
I think that, as the Chief Justice pointed out earlier, where there is a whole series of, sort of guidelines against that, so to speak, like the UCMJ prohibits the military from following a plainly unlawful act. If one adopted Justice Alito's test, that would fall outside. Now, if one adopts, for example, the Fitzgerald test that we advanced, that may well be an official act, and he would have to be, as I'll say in response to all these kinds of hypotheticals, has to be impeached and convicted before he can be criminally prosecuted. But I emphasize to the court that—
Well, he's gone. Let's say this president who ordered the military to stage a coup, he's no longer president. He wasn't impeached. He couldn't be impeached. But he ordered the military to stage a coup, and you're saying that's an official act.
I think it would depend.
That's immune.
I think it would depend on the circumstances whether it was an official act. If it were an official act, again, he would have to be impeached.
Well, what does that mean, depend on the circumstances? He was the president. He is the commander-in-chief. He talks to his generals all the time, and he told the generals, I don't feel like leaving office. I want to stage a coup. Is that immune?
If it's an official act, there needs to be impeachment and conviction beforehand because the framers viewed that kind of
If
very
it's an
low
official
risk.
act, is it an official act?
If it's an official act, it's impeachment.
Is it an official act?
On the way you've described that hypothetical, it could well be. I just don't know. You'd have to, again, it's a fact-specific context.
Well, that's great points. Interesting questions there. I want you to think about it yourself. See if you have a good answer. But let's go on to Justice Neil Gorsuch. Now, Justice Gorsuch is always good for a laugh or two not because he's just got a good sense of humor, but he also asks some really tough questions. And again, the purpose of asking the tough questions is really to make sure that the justices understand all the implications of the decision they're about to write. So here's a question by Justice Gorsuch saying, hey, why can't the president just pardon himself? What does that mean?
What would happen if presidents were under fear that their successors would criminally prosecute them for their acts in office, whether they're engaged in drone strike, all the hypotheticals? I'm not going to go through them. It seems to me like one of the incentives that might be created is for presidents to try to pardon themselves. Do you have any thoughts about that?
That is, didn't think of that until Your Honor asked it. That is certainly one incentive that might be creative. What we think is most important.
We've never answered whether a president can do that. Happily, it's never been presented to us.
And if the doctrine of immunity remains in place, that's likely to remain the case for those very issues. As Fitzgerald, I think, very powerfully emphasized, the real concern here is there going to be bold and fearless action? Is the president going to have to make a controversial decision where his political opponents are going to come after him the minute he leaves office? Is that going to unduly deter? Is that going to dampen the ardor of that president to do what our constitutional structure demands of him or her, which is bold and fearless action in the face of controversy?
And perhaps if he feels he has to, he'll pardon himself every 4 years from now on.
But that, as the court pointed out, wouldn't provide the security because the legality of that is something that's never been addressed.
Now, the next thing I want you to keep in mind is we've talked about the distinction between malum in se, malum prohibitum. This is one of those things that are foundational to viewers of the Four Boxes Diner. It's very important that you, as the smartest person in the room, understand this distinction between malum in se crimes and malum prohibitum crimes. Malum in se crimes are crimes that are just inherently understood to be evil in and of themselves, whether you have laws against them or not. Those are crimes such as, and you can guess, I'm sure you know what they are. They're murder, they're rape, they're fraud, they're burglary, they're physical assaulting, right? Assaulting people. Those are malum in se. They're evil in and of themselves. Those are distinguished from crimes that are known as malum prohibitum, which means they're wrong simply because the legislature says they're wrong. Again, jaywalking, the length of a shotgun barrel or the rifle barrel, or the number of ounces in a particular thing of milk that's sold, or any of these sorts of things that are just simply dictated by a legislature. There's no inherently moral evil component to them. They are the law just because we say so, or at least the legislature says so. So that's the idea. And here you have in the U.S. Supreme Court itself a discussion by Justice Sotomayor about this notion of malum in se crimes in the context of presidential immunity. Check it out.
It can be alleged, but it has to be proven. Malum in se is a concept long viewed as appropriate in law, that there's some things that are so fundamentally evil that they have to be protected against. Now, I think, and your answer below, I'm going to give you a chance to say if you stay by it. If the president decides that his rival is a corrupt person and he orders the military or orders someone to assassinate him, is that within his official acts that for which he can get immunity?
It would depend on the hypothetical, but we can see that could well be an official act.
It could, and why? Because he's doing it for personal reasons. He's not doing it like President Obama is alleged to have done it, to protect the country from a terrorist. He's doing it for personal gain. And isn't that the nature of the allegations here? That he's not doing these acts in furtherance of an official responsibility. He's doing it for personal gain.
I agree with that characterization of the indictment, and that confirms immunity, because the characterization is that there's a series of official acts that were done for an unlawful purpose.
And of course, we can't have a discussion of the U.S. Supreme Court today without a discussion of Chief Justice John Roberts. Here is a powerful hypothetical that Chief Justice John Roberts is asking about the difference between a private act and an official act, which could be a big deal, because obviously if it's an official act, there's no doubt that you would have absolute immunity. But if it's a private act, well, maybe there's a debate that purely private acts by the President of the United States do not give him presidential immunity. Or maybe that's not right at all. Hard to say. Nevertheless, let's see what Chief Justice John Roberts has to ask and say about the notion of bribery being an official act or a private act right now.
The indictment.
Well, what if you have, let's say, the official act is appointing ambassadors, and the president appoints a particular individual to a country, but it's in exchange for a bribe. Somebody says, I'll give you $1 million if I'm made the ambassador to whatever. How do you analyze that?
That, I think, would fall under this court's discussion in Brewster, where the court held with respect to legislative acts that bribery is not an official act, which also matches the common law background. So the way that this court in Brewster kind of sliced at the joint was to say accepting the bribe and the agreement to sex the bribe are not official acts. That's private conduct.
Okay,
subsequent appointment would be essentially an unrestrictable power of this court that Congress couldn't directly regulate.
It's not, accepting the bribe isn't an official act, but appointing an ambassador is certainly within the official responsibilities of the president. So how does your official acts or the official acts boundary come into play when it's going to be official, assuming that the president is innocent? But the whole question is whether he's going to be found innocent or guilty.
Again, I think Brewster and Johnson do address that, or very persuasively at least, in a slightly different context. Brewster and Johnson say the indictment has to be expunged of all the immune official acts. So there has to be determination what's official, what's not official.
Well, you expunge the official. You say, okay, we're prosecuting you because you accepted $1 million. They're supposed to not say what it's for, because the what's for part is within the president's official duties?
There has to be, we would say, independent source of evidence for that. And keep in mind that this indictment charges what this court has described as unrestrictable powers of the president. So the logical premise of this indictment is that Congress, by passing vague and general criminal statutes, has purported to directly regulate the president's exercise of things like the exercise of the appointment and removal power, things like his ability to speak directly to the American public, core exercises of his authority under the Recommendations Clause to recommend to Congress, members of Congress, the measures he thinks necessary and expedient. So you have an indictment in this case that goes right to the heartland of the president's powers, that alleges a whole series of official acts and tries to tie them together by saying, well, there's a private aim or a private purpose in that case, and that's a situation which, of course, could be alleged in virtually any indictment.
Counsel.
All right, folks, so as we wrap up, I just want you to take away from this video the use of hypotheticals. So it's very important that when we talk about the Second Amendment that you understand how these justices think, because it helps you as the smartest person in the room think about hypotheticals. And in the Second Amendment, when you're talking to like an anti-gunner or someone who's unsure, ask them hypotheticals. For example, if you're at home, it's the middle of the night, the police are nowhere to be found, and someone's breaking in your home and you don't have a gun, what is your plan exactly? In other words, what exactly will the plan be to protect your children in the room? If you're a 110-pound woman living in New Jersey, there's no guarantee the cops are showing up. People break into your home. What's the plan? Hypothetical question, right? What are you asking? So again, hypotheticals can play a very positive role in support of the Second Amendment, and that's why it's important for you to understand how they're used by the Supreme Court, because I can assure you, every time there's a Second Amendment fight, there will be a series of hypotheticals asked. So it's important that you in the Second Amendment community, we in the Second Amendment community, think about these hypotheticals ahead of time to make sure we have the best answers, whether we're asked by Chief Justice John Roberts in a case, or in front of Congress, or by friends, or a family member, whomever. We want to make sure we have good answers to the hypotheticals that we come up with first. All right? All right, hope you learned something here today at the Four Boxes Diner. Make sure you subscribe and resubscribe. We're trying to get to 150,000 subscribers here on YouTube. And don't forget to follow me on X at Four Boxes Diner. And we will see you again soon here at the Four Boxes Diner.
Orders up. Table 2A.